Okay, good afternoon, everyone. Thanks for joining us today for this webinar on getting paid in the construction industry. My name is David Wilson. I'm a partner in MF I've got 25 years of experience in construction law, and I'm an accredited specialist in construction law since 2007 with the Law Society. And I'm joined by my colleague, Lindsay Stark. She's also a solicitor within MF and has been with us for about 4 years. And prior to that, her previous life was as a quantity surveyor for a large main contractor before she was trained in law. The webinar today will be broken down into 5 parts. The first is a brief overview of the basic payment and construction contracts, covering what the law says in terms of entitlement to payment. After that, we'll expand on the payment cycle that's created by the legal system. Then we'll delve into a bit more detail on specific notices that might be required by the parties, and then onto the options that are open to you in circumstances where you don't get paid. And then we'll wrap up with some kind of key takeaways and highlights from what we've been talking about, and then hopefully we'll have some time thereafter to answer some questions. And on that point, I'll pass over to Lindsay, who's going to deal with the first part.
Thanks, David. I'm going to be touching on the legislation and what that says in terms of your entitlement to payment. There are several areas of law that govern your right to payment generally. However, the main act of law that you're likely to have heard of, and is likely the most relevant to you, is the Housing Grants, Construction and Regeneration Act 1996, which is just more commonly called the Construction Act. This piece of legislation is intended to ensure that payments related to construction contracts are made promptly and that construction disputes are resolved swiftly. This Act contains provisions that provides that you're entitled to the right for a date of payment and a mechanism that provides a payment cycle. You can see that in section 110 of the Act, which is on the screen at the moment. You're also entitled to the right to be paid in interim, periodic or staged payments, which, as you can see here, only applies to contracts over 45 days in length. A contract that is less than 45 days has payment terms under that that states that final payment is due 30 days after completion of the works. You also have the right under that to be informed of the amount due or any amounts that are to be withheld, the right to suspend your performance for non-payment, the right to adjudicate where disputes arise, not just in respect of payment, but for other disputes as well, and completely disallows pay when paid clauses. It is important to note that your contract does not have to be in writing in order to be a binding contract and one that falls under the terms of the Construction Act. It's also important to consider if your contract can actually benefit from the terms of the Act. The Act only applies to contracts which are related to construction operations. So what are construction operations? In the widest sense, the term construction operations might refer to any activity that contributes to the delivery of a construction project. However, the term is defined more precisely by the Act, whether works set out in a contract are considered to be a construction operation which affects the parties' obligations and rights to payment. I don't intend to go through all of the exceptions and the definitions of construction contract under the Act. However, the ones that I think are important to the audience that we have today are found in section B of the Act, which specifies that any work which concerns power lines, telecommunication apparatus, heating, lighting, air conditioning, ventilation, power supply, fire electrical protection, security or communication systems are all included under the Act. Despite this, there are a number of exclusions which you should be aware of, which include the works undertaken for individuals such as domestic homeowners. These types of works are excluded under the provisions of the Act. In these types of jobs, if you have a payment dispute, other pieces of legislation such as the Consumer Right Act governs and can assist you in those circumstances. If the work you undertake is not excluded and is not specified in Part 1, A, B or C above, as I've just said, your contract is likely to fail to comply with the Act. In this instance, the scheme for construction contracts may apply. What is the scheme? So the scheme either supplements the provisions of the contract where your contract has deficiencies in respect to that, or it will replace instances in the contract where any of the terms are non-compliant. This enables construction contracts to remain capable of performance whilst allowing regulatory control over the provisions inside. What the scheme does is it essentially fills in any gaps where your construction contract might be lacking. Among other things, the scheme prescribes a specific payment cycle and dates where a contract may not provide for this. The payment cycle to the unfamiliar can look quite intimidating, and here is an example of what the payment cycle under the scheme looks like. David will shortly explain the payment cycle more fully and begin to break down the various stages and what they mean to you. If you're undertaking electrical supply, installation, commissioning works or the like on a construction project, the Construction Act is likely to apply to your contract. And as such, you can benefit from the provisions in respect of payment. As mentioned above, if your contract lacks any details or a payment mechanism, you're entitled to make use of the payment provisions laid out in the scheme. I'll hand over to David now to describe the payment cycle in more detail.
Okay, thank you, Lindsay. Payment cycle. So as Lindsay's pointed out, the Housing Grants Act was introduced for the purpose of ensuring payments are made promptly through the supply chain and that disputes are resolved swiftly to achieve its goals. It created a right to be paid in stage or interim payments, and also states that construction contracts must provide a reasonable mechanism to establish what is to be paid and when. So if you take these together, these provisions in the Act essentially provide a payment cycle for these interim or stage payments, and also for the final payment under the contract. And as Lindsay's pointed out, it's where the contract doesn't comply with these requirements, the scheme for construction contracts will be read into your contract. In terms of the frequency of payments, the Act provides for requiring a relevant period to be specified. The relevant period under the Act is a reference to the payment cycle length for interim payments when they become due. And depending on the length of the contract, you might have a great number of these, and followed by the final payment. Final payment is often treated slightly differently to the interim payments. There will usually be separate contractual provisions dealing with that. To comply with the need for a relevant period, construction contracts will often contain a payment schedule with a list of dates that set out when payments will be made to one party or another. It can, however, be linked to completion of pre-agreed activities or stages, at which point the payments must be made. Where the contract doesn't provide for a relevant period, the scheme states that the relevant period is a 28-day cycle from the contract commencement date, so 28 days for every interim payment. So in terms of payment cycle for each interim payment, the first milestone is the due date for payment. The parties are free to agree the due date or how to calculate it, but if they don't do that, the scheme provisions apply, and the scheme states that the due date is the later of 7 days after the expiry of the relevant period, or upon the making of a claim for payment. Traditionally, that will be the submission of an application for payment, an interim application for payment by the contractor. The contract also requires a final date for payment to be specified, and that's the date, essentially the date when payment must be made. Again, you're free to agree, parties are free to agree when this is, but if not, the scheme says that the final date for payment is 17 days after the due date. During the payment cycle, there's also a number of requirements for notices to be issued. Now, this is so parties know what and when payments are going to be made. And the first of those, following on from the due date, is the requirement for a payment notice to be issued. This requires to be given by the paying party, and essentially sets out what payment they're going to be made, what payments are going to be made. In terms of the scheme, the date for doing that is 5 days before each due date. If the paying party fails to provide a payment notice, the contract should, and the scheme will add it in, a requirement for a default notice. So the contractor or the party receiving payment can issue a default notice, and that essentially sits in place of the payment notice to define what sum is to be paid. Thereafter, if the paying party intends not to pay the notified sum in full, there's an obligation on them to issue a further notice, which is is known as a pay less notice, just setting out exactly what has been paid and why what has not been paid. In terms of the scheme, the pay less notice requires to be issued not less than 7 days before the final date for payment. And again, let's hope to the parties to agree that time. These notices are very important parts of the process, so Lindsay's going to now go on and give a bit more detail on what they should contain in order to do the balance.
Notice clauses are, as David has mentioned, often contained in construction contracts, and these require a party to construction contracts to notify the other party in certain circumstances. For example, when they consider either extra time or money is due. The rationale for this is that notices promote greater certainty, and the requirements of contractual notices also help make communication between the parties to a contract clearer on such key issues. Notice requirements are particularly common in construction and often stipulate when claims for the additional time or money sought can be made, as well as when litigation or alternative dispute resolution procedures such as adjudication can be launched. It also can determine when a contract can be suspended or terminated. Some types of contractual notices in law are what we would call a condition precedent, which means that if the notice is not given, the remedy or relief that you may be seeking will not apply to be available. Payment notices are one such condition precedent. Broadly speaking, if you do not issue the correct notice at the correct time or in the correct way, you may not be entitled to the payment that you seek. There are very strict requirements for both payer and payee to issue and manage payment notices, which operate within the payment mechanism that David's more particularly described. Payment notices are very powerful documents and are the cornerstone to your entitlement to payment, or lack thereof, as the case may be. All notices must state the amount applied for and the basis for the calculation of the sum that you're applying for. The requirements are particularly described in Section 110 of the Construction Act. And the more detail and vouching you can provide in your notices, the better, as this will limit the risk in the future of disputes arising. If you are the payer, you must be certain of what the payment due date is, as there is an absolute requirement to serve a payment notice up to 5 days after the payment due date. If this time period is missed, it could potentially be a breach of contract with quite significant consequences. If you are the payee, which the majority of you on this webinar will be, and if the payer is in breach by failing to serve a payment notice within 5 days, the payee can serve a default payment notice, stating the amount due and also giving the basis of calculation. The contract may also demand that an application for payment be made by the payee. In such circumstances, the payee's application for payment automatically becomes the default payment notice. If such a notice is served, there is absolutely no defence to the amount claimed if a pay less notice is not served in the specific time. Pay less notice is issued by the payer when it does not consider the sum applied for to be due. If a default payment notice is left unchallenged after the last date for a pay less notice, it cannot be scrutinised by anyone, not even an adjudicator. The sum in that notice will be the sum regardless if the payee does not agree with it. This is another reason why you should fully familiarise yourself with the payment cycle dates. As I've just said, the pay less notice is the final opportunity for the payer to value the works and withhold monies, trumping the payment notices or the default payment notice. However, the pay less must be valid, i.e. it must state the amount and the basis for the calculation. It must also be the true value of the work which has actually been undertaken on the date that it's served, and that can be scrutinised by an adjudicator. The details of what a valid PLS notice must contain are noted in section 111 of the Act. However, it's important to note that caution should be exercised by the payer, as it may be that a further month or stage of work has been undertaken. And this will have to be included in the PLS notice value, which may negate the intended reduced value. PLS notice must also be served before the time stipulated in the contract, which is the date which is before the final date for payment. In the scheme, the time for service is no later than 7 days before the final date for payment. And a PLS notice cannot be served before an application for payment. In such a case, if it is done so, the PLS notice would be invalid. In the case of all payment notices under a construction contract, timing and content of each is absolutely critical to their validity. There is going to be no grace given for mistakes made, so great care should be taken by you to ensure that your notices are managed properly. If notices are ignored or mismanaged by either party, this can lead to significant dispute and delays in payment of sums that could be properly due to you. I've mentioned a few times that all notices must be valid, but what does that actually mean? There are a number of requirements for a valid contractual notice, and many of these requirements may be listed in your contract. These requirements must be followed very closely to ensure that no dispute as to their validity can come at a later stage. In our opinion and from our experience, in particular, we would advise you to always check whether a notice is actually required in the particular scenario that you find yourself in, where the notice should be served, how the notice should be served, on who the notice should be served in particular, what the time limits are for service of the notice, and what particular details that each notice should contain. Getting notices wrong, even down to how it's delivered, for example, can have costly consequences. Failure to do so could prevent a contractor from getting additional time and money to which he's entitled. Some common issues that are encountered when serving notices, which are easily avoided, include serving the notice on the wrong address or to the wrong person. It's not only vital to be aware of the contractual requirements, but also any properly notified changes in correspondence details post-contract. Serving the notice by a different method than that it is stated in the contract. So examples would be delivery by hand, by post, by special delivery post, by email. As a general rule, a requirement for a notice to be in writing or in written format will include electronic communications such as email, unless this is specifically excluded. However, always check your contract because it's not uncommon for emails to be excluded. Lack of proof of valid service. For example, does the contract assume that the notice has been received after a set period of time? That's what we would call deemed service. If that's not the case, can you please ensure that the proof of delivery of a notice is sought at the time of service? So that could be by recorded delivery or by a read receipt on an email. All of this is really important to make sure that your notices are valid. But when it does go wrong and you don't get paid, David's now going to have a look at various problems that happen and how you can remedy them.
Okay, so just in terms of at the stage of when you've got a dispute and when you don't get paid, there's a number of options open to you in those circumstances. The first, which is most informal and least most cost effective, is negotiations. Basically, speak to the other party. That's often the starting point for this process. It can be undertaken with the help of a legal representative, but that's not necessary. And often negotiation is enough to get you over the line and get payment or an acceptable payment made. As I said, it's the most cost effective route and can often lead to preserving relationships with the other side. If negotiations are not getting anywhere, often the next step in that process is what we'd call a legal letter, where you'd instruct a solicitor to issue a letter of claim. Normally the letter would set out your entitlements, notices and demand for payment, and a threat of escalating dispute resolution. The threat being that there'll be increased costs for the other party. And that's, again, it's a common method of resolving disputes. It's inexpensive and it's often very effective. Another option for parties is to look to the contract. As Lindsay's pointed out earlier, one of the entitlements under the Housing Grants Act is to suspend the works, suspend the performance of the contract because as a result of non-payment. That's open to parties if there's some certified within a payment, an interim payment that's been certified, there's been no valid pay less notice in place, and the final date for payment has passed, then that would entitle you to issue a notice to suspend the works. Now, crucial point there is it's you issue a notice, you to give 7 days under the scheme, and only after the 7-day notice period, and if payment has not been made, can you legitimately suspend. Now, it's one that I always recommend to clients that they take great care of over suspension process, because the consequences of getting it wrong can be quite significant if you down tools on site, and then there could be quite substantial claims coming your way for breach of contract if you've got the process wrong. So in terms of the next kind of option open to parties to start to get more formal is mediation. Now this is a consensual process. It requires everyone to sign up to it. It is a formal process, the appointment of a third-party mediator to facilitate negotiation. So it's a formal negotiation in an attempt to resolve the dispute. And it's got a number of advantages. It's informal, it's confidential, it can be started at any time, can be restarted if it fails. It often allows commercial relationships to continue during and after the dispute. And ultimately the aim is that it can resolve the dispute in a binding fashion, sign up to an agreement at the end to resolve the dispute. There are obviously some downsides. Process is not binding unless you sign up to a binding agreement at the end of it. So potentially you could go through the process and it fails, and you can cover the costs of the mediator and your own time. Mediator also has no powers to order anything. It's not a determination. Mediator is only there to facilitate. And another potential downside is that you might disclose as part of the process some information that you might not, you might cause you problems down the line if the dispute continues. Then there's other formal dispute resolution processes. First is adjudication. That's again, as Lindsay said, something that's an entitlement for construction contracts, for parties of construction contract to have disputes resolved at adjudication at any time. It's again more formal than the other processes we've talked about. It's also more expensive, time consuming, and it can often require experts input in terms of quantity surveying for payment or just extensions of time, delay experts and so on. It is a statutory right. Often it is in parties' contracts anyway. Process involves having an independent third-party adjudicator appointed as a decision maker. Usually that's got the advantage of being a construction professional. So for a payment dispute, often you'll have a quantity surveyor will be appointed with quite a lot of experience in the area. It's a quick process. The statutory adjudications are essentially to be done within 28 days. It can be extended in certain circumstances, but that's by consent, but that's the original aim, is a 28-day decision, start to finish. It involves formal submissions to the adjudicator of the dispute, and might involve site visits and meetings with the adjudicator to discuss the issues. The main benefit of it is, as I said, is it's a quick process and it's binding unless it's finally overturned in court. The downside of adjudication is that it can be quite a rough and ready process. The adjudicator comes to this fresh and has to make a decision within 28 days. So often it can be rough and ready. And the other main downside is that, unlike court, you're not entitled to, so if you instruct solicitors, you're not entitled to any legal costs adjudicators can push portions of the cost, but your own costs can't be recovered. That then takes us to litigation, and kind of put this in together with arbitration. Two different arbitration is more like adjudication, but it's got a similar status to litigation, essentially a court action. Both litigation and arbitration are final and binding. It's usually the final port of call in a dispute, subject to obviously appeals of the higher court. It's a significantly longer process than adjudication. It can take years rather than months, and time is money. The longer it goes on, it's much more expensive as well. The upside of it is it's a final binding decision, but you will need to instruct lawyers to deal with it. So that's the main processes for resolving disputes, and I'll hand back to Lindsay now just to consider some key takeaways from what we've said so far.
Thanks. I appreciate that a lot of this has been quite legalistic and often difficult to wrap your head around. So I'm just going to recap with some of the key points which we think is really important for you all to remember, and ways in which you can minimise issues with payment. First and foremost, check your contract. Does the Act apply? And if not, you might have other legal remedies available to you. Get the contract in writing and ensure that all of the key details that concern payment, such as the payment dates, are included from the outset. Check your payment cycle and diarise all the dates somewhere so that you never miss a single notice. An ambiguous and incomplete contract will create problems later. So the clearer it is, the sooner and the clearer that the contract is, the better for you. The more information that you've got to hand before work even begins on site, the better. It's always worth the effort when disputes can be more easily managed, and more importantly, won down the line if you've done all that upfront work with the contract. Thirdly, be fully aware of your notice provisions. Familiarise yourself with exactly what you need to do and when you need to do it. Know what information needs to be required in your notices, when your notices are due, and how you have to properly deliver your notices. If you comply with your notice provisions 100%, this is going to eliminate a lot of the potential problems concerning payment in the future. When you don't get paid, don't immediately stop works or walk off site. Only do this and suspend works if you're fully confident that you've complied with your obligations fully, because you want to protect yourself in breach of contract. Finally, when in doubt, seek legal assistance. Payment disputes are a huge part of the work that construction lawyers do every day, and often a simple letter from one of us to the contractor can result in payment of dispute. Failing that, you have lots of different dispute resolution options available to you, as David has just said. And on that note, we bring our presentation to a close, and we invite anyone who may have any questions for us.
We have one or two questions in advance. If there's questions at the moment, one of the questions we were asked was, can we claim interest if we've got an outstanding payment? The answer to that is that first place to look is your contract. Often the contract will have a provision in it that specifies when interest can be claimed and the rate that applies. If you don't have a relevant interest clause in your contract, there's also statutory provision that requires interest to be paid, which is the Late Payment of Commercial Debts Act, and that specifies a certain percentage over the bank base rate at the relevant time. And so that's essentially where you either look to the contract or the Late Payment Act.
Another question that we received in advance was, can I be paid for goods and materials that I've got stored on site? In response to this, we would say that, similar to the question that David's just answered, that you need to look at your contract. There's no general right for payment of any goods and materials that you have on site simply because they've been delivered there. the right to payment for them is governed by your contract. Many contracts will permit payment for on-site materials and goods, provided that certain conditions are satisfied, such as they've been delivered on a certain date and they've been stored correctly and they've not been taken to site prematurely. But ultimately the answer to that is your contract will typically state the situation of goods and materials on site. Does anybody have any other questions for us? If you later after this seminar have a question that comes to mind, you do always have access to our legal helpline, the Select Legal Helpline, where if you do have any concerns or questions, you can pick up the phone and one of our construction law team here at Morton Fraser McRoberts will be more than happy to assist you with any queries or questions that you might have.
Thanks, guys.
Okay, well, if there's
Okay.
no more questions, we'll bring the webinar to a close.
Thanks, both.